Hello, everyone. Welcome to a very special Talking Feds on a very, very special day when the indictment against Donald Trump, first ever of its kind, was unsealed. No one I'd rather be here to talk it over with than Norm Eisen, who has been indefatigable in following it and producing all kinds of resources, unless it be perhaps Andrew Weissmann, who may be joining us if Ari Melber lets him out of his clutches. He's right now on set. But Norm and I have plenty we can talk about. We could go for hours, but let's just launch in. So, Norm, thanks for being here. Let's start here. Favorite paragraph of the indictment?
Paragraph 3, where in what is known as a speaking indictment, right? Smith has decided to tell a story here, not to do the bare minimum the law requires. He utters what is, I think, perhaps the most damning indictment in every sense of the word against an American president ever, where he itemizes the classified documents Trump stored in his boxes, information regarding defense and weapons capabilities of the U.S. and foreign countries, U.S. nuclear programs, potential vulnerability of the United States and allies to military attack, and the plans for retaliation in response to such an attack. And the special counsel goes through and itemizes the extraordinary damage that is represented, Harry, by having that kind of material removed from the secure setting of the White House, put in a totally insecure place. I also love the paragraphs with all the pictures of the different rooms
strewn everywhere,
these boxes, and how they busted open and poured all over the floor. And the danger that represents. And when I read that, I didn't only think about the paper that contains these shocking secrets. I thought about the humans who stand behind that, Americans, allies, sources, often in hostile lands, who gather the intelligence. Their lives are put at risk. And why do they gather it? To protect Americans and our allies and the world. So everybody's put at risk. That paragraph was so powerful, and it summed up the why of this case. We know the what. You and I will talk about that. This is the why, and I think the American people are going to get it.
I would think so. He stressed that in his unsurprisingly short public statement today, but he went through exactly the points you made. He traced it first to people who could be killed, and then to the national security and the danger to all. And it's like a 12-year-old who doesn't clean up his room, except it's like nuclear material everywhere.
That's
a really good one.
It's like a 12-year-old who's playing in a plutonium sandbox.
Yes. He comes across 12 off. I want my documents. But maybe 12's too old. Maybe more like 8. All right. So my favorite, though, in general, no new chapters, but some of the details, and the one that I'm blitzing through it, going as fast as I can, and the one just was paragraph 54, when so they've received the subpoena, and he's trying to figure out what to do. And I think he says, I think this is to Corcoran. I wonder what your opinion is on it. Corcoran and Nauta seem to be they're going to be the big witnesses, but he says, thinking it's protected by attorney-client privilege or not even knowing, well, what happens if we just don't respond at all? This is a fucking subpoena. We don't play. Wouldn't it be better if we just told them we don't have anything here? Well, isn't it better if there are no documents? The cavalier, the combination of the cavalier attitude with the seriousness of the transgression, and also you're totally right about the danger, but also so beautifully Trumpian. All the obstruction stuff and the basic, this is mine to do with what I want. So I was pretty arrested, as it were, by paragraph 54. All right.
Can I say something
please.
about
And you
paragraph
can also
54?
offer the questions, or I'll keep. I got a
I
million of them.
have my
Yeah,
question for you. I have my
yeah.
first question for you.
I'm thinking as a prosecutor. You're thinking as a defense. Well, you're thinking
I've
both
never,
ways.
well,
Yeah.
the only case I've ever prosecuted is one of the few trials of a president in American history for
Yes.
crimes and misdemeanors. In that case, it was for high crimes and misdemeanors.
I think I remember that one. Okay.
But I also had paragraph 54 in my monster Twitter thread. I read the document in real time, and so I just turned the pages. I launched with paragraph 3. That's what inspired me when I read that paragraph. I'm like, oh my God, I have to start tweeting, right? And I did screenshots of each of the important paragraphs. But I came to paragraph 54 and it jumped out at me. And of course, they've turned Trump's lawyer against him. And that is one of the most unusual and devastating and valuable things that a prosecutor can do. And to me, as a defense lawyer, having clients who trust you and talk to you about their secrets, the thought that I would be forced to turn around and do that. And what's more, so the statements in that paragraph are absolutely damning. I did think like a defense lawyer, Harry, which is we know there are.
Give us
Yeah,
your thoughts as a defense lawyer as you
as a
blitz through it.
defense lawyer, well, on this paragraph, I'll give you an example. They cherry picked 4 sentences out of 51 pages of notes. So when the defense gets the context and the other things and what was omitted, that's why it says speaking indictment. You choose what to present, right? You don't present. The defense will have some counterpunching on that. As I wrote for the New York Times today with Weissmann and Joyce Mans, there are challenges. And of course, we're going to talk about, this is my first question for you. I think all of us were feeling pretty good about the rule of law, Harry. But how did you feel when you learned that Judge Eileen Cannon, who made those completely lawless decisions that were reversed at first in a stay and then in a judgment of the 11th Circuit, itself quite conservative. How did you feel when you learned that Judge Cannon was going to be assigned, at least initially, maybe permanently, if she's not forced to recuse or if she's not reassigned? How did you feel when you learned she was assigned to this case?
Right. So a few things. First, I think we've talked about this. It looks like it's very likely that she'll be absent recusal, the trial judge, but we don't know for sure. It just seemed kind of head spinning that, could a wheel, a random roll of the dice actually have produced her, or are there some internal rules? We're still studying that, but you're so right. I mean, remember, she wasn't simply. There have been some judges that I think have been biased toward Trump in the last several years. She was heads and shoulders the worst because it's not just her. It was the entire expedition with Judge Deary and just accepting Trump's civil overtures in the first place. She was really really bad. Here's what I thought. I mean, it's true. Well, I thought two things. So I'm going to do an answer and then a question to you for us to mull over. The first thing I thought is, look, it's going to be a jury that's going to determine this. Even if there's, one or two jurors that go the other way, the United States will retry the case. So it's ultimately not going to be for her to dismiss it. But she is, by dint, not simply of partisanship, but just competence, as in not a real risk for letting Trump have his way with delay. Having Trump, he's just changed his counsel. He goes in first thing and says we need, a few months to. She can give with, would have a lot of discretion. You can't see her getting reversed. And this trial, I mean, one of the few things that Smith said is about speedy trial, and so that I was the first risk that came to me. Let me ask you then, what do we know? And I think it's still kind of reading tea leaves about the final move down to the Southern District of Florida. Could they have thought that there was a real chance they would get her? And isn't this one of the nightmarish possibilities they were factoring in? How the hell did it happen in terms of the DOJ's overall move? Or do you think it's just total surprise?
I think that the essential conduct in this case, that's the test for venue, Supreme Court test. And I think the essential conduct in this case predominated in Florida. This wasn't even an instance where you could say, well, like in the Manafort case, we'll split it between two jurisdictions. It really was a Florida-focused case. I don't think Smith wanted to start the matter by, giving Trump a venue argument, maybe a meritorious one in D.C.
But didn't it feel to you that at first they did? I mean, that there was a switch made somewhere around the beginning of last month?
Smith inherited D.C. grand juries, right?
Oh, good point.
So he wasn't the one who initiated. And I think that, they came to a point where they said, look, this really belongs in Florida. It's, it's honest lawyering. It's like, that is what prosecutors are supposed to do, right? If the essential conduct is Florida, they're not supposed to charge in D.C. to get a tactical advantage. He must have known there was a risk of getting Cannon. To my understanding, the case is in the West Palm Beach division, because that's where Mar-a-Lago is. That's where, again, the essential conduct is. There are 3 federal judges in that division, plus Judge Cannon, who they help her and she rotates to help them. So it might have been the wheel. It might have been a modification of the wheel plus the chief judge, looking at workloads and other considerations. I will learn more about that as we deal with the Florida experts. I used to have, when I was in private practice, my firm had a Florida office. And, my colleagues had interesting reflections, as you know, my former colleagues.
Florida.
As you know, Florida, it's sui generis. So that is my take on Judge Cannon. Does your experience, is it my turn or is it your turn?
Well, no, let's keep talking about her, and in particular, whether you think there's any chance that she says, why do I need to be a national punching bag for the next year and a half? I can't win given where I've started from. I'm going to recuse.
She should recuse. She should recuse. It's an appearance of a conflict. We need to, we'll need to help educate on the judicial recusal statute, on the Martin case, U.S. v. Martin in the 11th Circuit, which is the binding authority. I don't think that she's going to recuse. Judges are very resistant to recusing just because litigants and the public don't like their opinions in a case. I don't see it. She saw what was coming at her the last time, and she was absolutely contumacious.
She doubled down, in fact, twice.
She did.
You're right.
And so that leads me to my question to you. Now, she may be, her hand may be forced by the 11th Circuit, because this there is authority in the 11th Circuit that a pattern of irrationally unfair decisions counsels reassignment. And the circuit may feel, these repeated decisions from her on the special master were so far out. It's not, it's not impossible. And then there's the judicial, there's the appearance of a conflict. Boy, there's a profound issue because her opinions were so peculiar. Now, let's accept the possibility she might or might not. If she doesn't, can Donald Trump obtain an unfair trial? Can the prosecution get a fair one with Judge Cannon on the bench? Talk to me about, first, about the ultimate trial. Will it be fair? Do you trust the jury? Are the rules strong enough? Is the 11th Circuit oversight powerful enough to deliver a fair trial? And then explain your delay point, the when.
Got it. Okay, and then I got my comeback for you. But you're right, I blitzed through and I was thinking as a prosecutor. So it's very, very strong evidence, and there's only so much she can do to limit it, I think. And the clearly admissible statements, for example, in my favorite paragraph, one might think of that as hearsay, but it doesn't matter. It's defined as non-hearsay because it's out of his mouth. An interesting point that I don't think people have really cottoned to as far as evidence and admissibility goes. It matters under the rules, as you know, if notes are contemporaneous. I think what happened is after a few weeks, Corcoran had an oh shit moment, and
he
while
did.
driving
No
or something,
question.
he took out his phone and just dictated. That's not the kind of thing that usually counts for getting in because it's not contemporaneous. But let me be my little nerdy prosecutor here for one sec, Norm. It's still I think it was very important that those quotation marks or the actual verbatim accounts in paragraph 54, because the statements, if he just says this is what he said, that will come in. Anyway, she could make certain controversial rulings, but she is, they start with more than enough. Do I trust the jury system? I see no way, even, in what would be the very worst jurisdiction we could think of an acquittal. So I see the possibility that, first of all, the first thing we're going to worry about with her is voir dire and whether she'll let people through who it's pretty clear are very pro-Trump, but say they'll be fair. And that could be a real dust-up. And so could there be a couple people on the jury who are really true believers? That's a risk. And of course, we've had them in two different trials in the past, and the jury system has worked. They've come through, notwithstanding their ardor for Trump. But here, at worst, and this is not great, but at worst, I think you'd get a holdout juror or two, hung jury, mistrial, and the
government
US would retry it. Okay, but as to delay, look, the reason he said speedy trial.
Yeah.
I don't say this as a Democrat, though I am one. It's pretty damn important for the people to get. It still looks overwhelmingly, even maybe more so, we'll see, that he's going to be the nominee. And it really matters that the people have a chance to make their determination whether they're for him with how weird would it be if nothing happens and then he's convicted 3 months in or whatever. I think you could still be able to serve. That might be a different question to talk about. But the people deserve a chance to know the judgment of society about Trump's behavior when they go to the ballot box. And the worry about delay here is there's 16 things, and Trump will make them 32 to try to occasion delay. And without any of those things, we're maybe looking at next summer. And so she could easily and irreversibly bounce it past November. My question to you as defense attorney, you read through and you get to the stuff about Walt Nauta, the other person charged, co-conspirator, the, variously described as a valet and a Diet Coke gopher. What are you thinking? You represent now him, not Trump. So in your mind,
Oh my God.
what's his situation? How are you gonna
I never would have
advise him?
Harry, I never would have let it get to this. Nauta should have
Yeah.
pled. He should have cooperated. He does not have.
I don't understand why he didn't after he lied, right? They had him dead to rights. But here you are, in Trump land, new lawyers come cycling in every few weeks.
Well, and
here,
he's
you've
loyal.
just been handled. Here, Norm, here's your new client. What are you going to do?
It's
you got to play the hand you're dealt.
It's also the Weisselberg phenomenon, right?
Yeah.
That
right.
Trump does inspire this kind of loyalty. You and I know Michael Cohen, who was once that loyal person and now has, who saw the light. I just think it's terrible. This was in my live tweet as I read the complaint. My heart breaks for Nauta. I worked when I was in the White House with these Navy personnel who work as stewards, valets, White House mess. They're good and decent people. Nauta got sucked into Trump's world, and it's very tragic. So I also wish Nauta had not participated.
They surely tried to get him to cooperate before charging him with a conspiracy, right? What can he do now?
Well, he needs to get a new lawyer. I don't know. Do you know who his lawyer is?
No, I know who. There was a pretty good lawyer who was handling this unknown associate who helped him with the boxes and then got all nervous about the surveillance tapes. Is it Stanley Woodward, who's pretty well known down there? It's a pretty good guy, and Trump is paying for it. I figured that out a few weeks ago. So a well-known person, not and it might be Stanley Woodward. He's an old hand in the Miami world. I'm sure your Zuckerman colleagues know. But the short answer is I don't know. But he's got solid counsel. But he decided not to. Right? I mean, my God, they had him dead to rights, and he decided indict me.
That's loyalty. But it's misguided. So I felt sad for him. Trump chose this. Nauta's a civilian to the legal system, although he's the Navy man. And how tragic that he got sucked into this. Corcoran was not named in this complaint because he protected himself.
He was exonerated. They really, I think he got a really good bill of health.
Who knows if he would have been exonerated without those 51
No, I'm just saying the
pages.
Indictment goes out of its way to make it clear he was hoodwinked.
And I think prosecutors recognize that he was helping himself and jeopardizing his client by making that 51-page document. As a defense lawyer myself, I 100% guarantee to you that Corcoran made that. And he's a very capable, well-respected defense lawyer. He made that. He realized, oh shit, I could be on the caption of this case. When I was coming up in D.C., Harry, it's when we first were friends in the early 90s, first met each other. We defense lawyers lived by the dicta of Edward Bennett Williams. He was the great figure of the defense bar, passed not long after. And one of his aphorisms was, only the clients go to jail, never the lawyers. And Corcoran, that is also a truism. You're dealing sometimes as a defense lawyer, and I was a smidge of an abolitionist early, 30 years ago, right? I chose to be a defense lawyer. I'm not knocking prosecutors. God bless them. You're a dear friend. And I literally have dozens and dozens of beloved friends and colleagues and prosecutors who I adore and respect, and no knock. I made a choice to be a defense lawyer. But and I'm proud of it. And there's a lot of innocent people who I spared, sentences I reduced, death penalties I bargained down to helping a person stay alive. I'm so proud of all that. Occasionally, however, in my practice, because you are representing people who are accused of serious misconduct, and particularly with white-collar criminals, with organized criminals, organized crime figures, I did much, much more white-collar. There's a different bar that does OC. But they have the same problem. Occasionally, your client attempts to enmesh you in something that's not quite kosher. That happened with me very rarely over 30 years. Corcoran found himself in that situation, and he dictated that memo to protect himself. And Harry, it worked. It worked.
Totally. Right. Yeah, those notes are going to be a star witness, I think, if they come in. We've talked about it, but the main stuff, I think, does. Let me ask you, speaking of Nauta, and I guess it's not inconceivable for the former president, have we definitively passed the point where the case could be resolved on a plea? You know, if certainly Nauta, comes
Nauta,
and,
yes,
and
Nauta may blink. He may do a Weisselberg, but the difference is he's looking at.
You mean not take cooperation, but tell the truth and fully. But of course, now he doesn't have to testify.
Weisselberg took a light plea and refused to roll over on Trump.
Right.
You know, there's questions about whether he was as candid as he should have been. I don't know if we've seen the end of the
last of him, right?
You know,
poor guy. Okay, so you can actually see
I'm
that.
not done.
Well,
I'm not done. Trump, as I wrote in the New York Times, as we wrote in the New York Times, no effing way. Can you honestly imagine him? This was Joyce's line, standing up in court and saying, "I plead guilty because I am guilty."
Which he'd have to, by the way. You'd have to cop to the factual elements. But look, here's something that's just tricky. This is now played. We've talked all the way through. Is it the right thing? Is it serve the public interest? Is there sort of an X factor? And it turned out that once Garland appoints Smith, there's no room for that inquiry. It's just on the normal track. All right, well, that's one thing for guilt. But that normal track also entails sentencing recommendations and advocacy by the United States. I don't see now how they don't ask for serious jail time if they get a conviction. And remember, we have January 6th still in the background, and I don't see how a judge completely departs downward. So, from a Solomonic perspective, what you might have thought would be the right choice for society of he's convicted, we get him the hell out of our hair, but he doesn't die in jail. It's not clear the system now that he's in the jaws of is nuanced enough to achieve anything like that. But certainly the time to try to plead for a non-custodial sentence, but what would have been last Monday. But it suggests, right, that he's got one legal play, which is winning the presidency. Other than that,
you read my mind. But it's multiple plays, Harry, because if he wins the presidency, he immediately pardons himself of all federal charges. But if another Republican wins the presidency, particularly a Trumpy Republican, like the MAGA, no BAGA, no baggage.
That's worthy of Trump himself, right?
The MAGA, no
Mr.
BAGA,
sanctimonious, right?
Ron DeSantis himself, by the way, with some uncomfortably close flights drawn to the moth-like flame of criminality. He's a scheme that he proudly proclaims he cooked up is the subject of a criminal referral from Texas law enforcement to prosecutors right now, tricking migrants into flying from Texas to Martha's Vineyard. That is very likely.
And also a different time to California.
So if it's not Trump and if it's DeSantis, I'm so tempted to keep saying MAGA, no BAGA, but I think I've worn it out for now. If it's DeSantis,
no, you got it.
You're going to see a MAGA Jerry Ford move. You're going to see, very likely sweeping pardons, including, by the way, for J6 defendants. And so, and even as you inch away from the autocratic MAGA extreme on the spectrum, I could see some of these other presidents saying, let's turn a page. That's the devastating part of the delay game when you combine it with, the non-zero chances of a Republican president. However, Harry, let me ask you.
No, it's a good point. Clemency, even from a Democratic president. Yeah, I'm sorry. Go ahead.
No, not from a Democratic president. No way. That president is a one-termer or an impeachee.
And the second term, yeah.
A self-impeachee.
All right. You got one for me, though. Fire away.
Yeah. Here's my question to you. Doesn't the complexities of these federal proceedings, plus the coming maybe Jack Smith January 6th related charges, there are strong charges there that I've written about as well. Doesn't the risk of a pardon or a possibly unconstitutional self-pardon emphasize the importance of the 2016 election interference and false records case that Alvin Bragg has brought in Manhattan, and of the coming Mondo, Georgia 2020 election interference case?
Yes. And, you and I will pat ourselves on the back. You and I have been, I think, rightly focused first for a long time on Fulton County, and then as it emerged on Mar-a-Lago. Al, I will say, in fact, let's a lot else is going on, but you've really been closely tracking it. And I know your current view is that she is planning to go really big and not only have potentially 15 or more defendants, as the special grand jury recommended, but a state RICO case. That just, as a prosecutor, and I'm thinking of your New York Times op-ed this morning, the adage that so many prosecutors honor in the breach. I don't know why. You see it again and again. They screw up and they don't keep it simple, stupid. And they do try to throw in stuff and they don't have a solid story. All those things that mark a good prosecutor. I'm worried, or objectively speaking, I think there's a strong risk that she is really coming out of the box strong in August with a total sprawling mess of a case of the sort that, at least historically, huge defendants, complicated charges, don't have a happy history. So I wonder what your thinking is about. I know your sense of the tea leaves is that they're really seriously thinking about going that route. Does it not worry you that it could just be a kind of a sprawling mess?
Keep it simple. That's my mantra. I wrote a piece earlier.
A lot of prosecutors don't. Right.
I would cackle with glee when DOJ would, as they're so prone to do, overcharge these cases. I know it's a frustration to more of the down and dirty trial lawyers like the two of us out in the hustings. since I count you as one because of your Pittsburgh antecedents and U.S. attorneyship. The Littman family.
Tree of Life capital case going on there now.
Yeah.
But I digress.
When I go to Pittsburgh, they still talk about your mom, all the time. DOJ classically overcharges, and I would love that as a defense lawyer. It didn't mean I won every one of those cases, but it gave me something to work with. I will say that I think Fani Willis, however, is more likely than not to do a big sprawling RICO case because it was a big sprawling conspiracy to overturn the 2020 election. The charges must fit the crime. I think.
Well, wait a second. Let me push back now, because the crime, if you're really zeroing in on solicitation to commit, you're right. A lot of players and almost two different crimes, the electors and the other. But you can zero in, as Smith basically has, although he, 793 and 31 different counts. But you can zero in on the specific, strong arming and thuggery of the January 2nd call and the like. RICO is basically alleging that it's a criminal enterprise, not a snapshot of different crimes, but like a moving picture of a criminal business rotten to the core. It just strikes me as a recipe for complications, added on to, of course, to the 15 plus folks. Now, you are not your Fulton County prosecutor's keeper, but I just wonder if you share those concerns.
Of course I do, but she's proven she can do this with maybe what was an even more controversial and complex case, equally complex case in Atlanta, the Atlanta teacher cheating scandal. Major RICO case, went on for months and months and months, got sweeping convictions. I think she's preparing this case as if democracy depends on it. And you know what, Harry? Depending on how these federal cases go, it just might depend on her and Bragg. Don't forget, I think of those cases as the four horsemen of the Trump apocalypse.
Yeah.
Bragg, 2016 election interference and false records. Willis, 2020 election interference. Smith, one, interference with the government's retaining, returning, and investigating his handling of its documents. So it's another kind of interference. And then the fourth case is the federal 2020 election interference. 4 criminal interference cases, because that's what Trump is about. Since I started,
that's who he is, right?
I saw it when he interfered.
It's not just serious; it's so Trumpian, right?
So it's inevitable that once he started on that slippery slope. I would write with Richard Painter once a week about emoluments and ethics violations and kind of the more serious but petty offenses. Hey, this is going to lead to crimes. He's going on the slippery slope. His interference with the normal operation of the Constitution and laws, civil, criminal, regulatory of the United States. And now he's got the worst interference problems you can have, criminal interference. When I read that Corcoran paragraph, was it 54? Yeah. I tweeted, this is where you end up if you start in the first second of your administration by violating the Constitution through taking these foreign funds, right? He didn't give up his businesses. So the money was coming in from impermissible foreign sources minute one. That's where you start, you're going to end up with these criminal interference cases. Then, of course, there's also the They're the horsewomen of the Trump apocalypse. E. Jean Carroll coming after him, the libel case, that was very important. The New York AG, the brilliant Tish James, she's got a civil quasi death penalty case for the Trump org. Nobody's talked about that I've heard in this conversation these past days. Hey, it's the great one.
Look what the cat dragged in. Hello, Mr. MSNBC superstar. I propose, Andrew, because, Norm, because we've been going for a bit. I want to make one quick point and then just let Andrew kind of give some basic thoughts so we don't. I would love to do another hour until his next appearance, but I don't think we have it, and he might need a bathroom break anyway. I just want to say quickly on your big hope about the pardons, my strong sense is, were he actually to win the presidency, the Supreme Court and the courts would hold that even a state prosecution, valid, but he couldn't be incarcerated until after his presidency were over. That's my best guess. Hello, Andrew Weissmann. Have a bite? Relax. Show us in.
That basically was a slice of pizza, which consisted of breakfast, lunch, and dinner.
And there's a New York guy. They're back in New York, I'm told, to the old-fashioned sort of charcoal-y pizza. All right, I'm going to tell you what we've talked about in this last hour, which is everything, and just ask you to give some thoughts, and we'll cut your break on too much time. Thanks for joining. Thanks for Ari Melber for letting it. But these things happen when you're a superstar. But look,
Andrew, we had a great time. Harry and I have been friends since like 1991. And we had a great time. And now we're so glad that you have. It's like when the party.
Exactly. Right.
Harry used to come to my parties.
Yeah.
They were good parties.
I was like mere props at that party for it was just ways to get different people of the female sex in so Norm could work the room, which he did beautifully. But enough of that. I will say, Norm, back at you. Andrew and I have a side arrangement as a result of which I owe him some very high-end liquor or wine, and you can share with it. Andrew, we've talked about
our reason I'm on.
It's exactly. We've talked about our favorite paragraph in the indictment. We've talked about what's new. We've talked about Walt Nauta.
Okay, but what was your paragraph?
All right, I'll just shut up. Go ahead. Talk.
What was your favorite paragraph? Because I'll tell you my favorite paragraph.
54.
Oh, it's so funny because mine is 55.
Oh, really? Aw. Norm chose 3. 6 had honorable mention. But man, I mean, the arc was what we expected, but those details, that shit that he said to Corcoran is amazing.
Yeah. So I mean, that's one of the things I was going to say. I mean, obviously the big picture is the seriousness of the case. I mean, if you're not looking at this the way you two and I look at it, which is more as a evidentiary, and sort of we think about it in terms of like, how's the case going to go? What's the defense going to do? Right. Do they have? What's their evidence? What are the weaknesses? I mean, that's just sort of like built into our DNA at this point because we're all a bunch of old codgers. Right. So that's sort of like, I think, how we just see the world. But if you step back, the thing that I was sort of struck by was that, having been in those meetings where the intelligence community thinks about what it is that a criminal prosecutor is going to be allowed to use and what they're not going to be allowed to use because it compromises too much national security interests, methods and means, things that you really need to keep secret. I was just struck by 21 counts of top secret information and the descriptions of that information. Was quite remarkable. But then I turned, and obviously the obstruction, the details of the types of obstruction, and that sort of gets to the second point, which was the source of the information is so incredible. You have it. I mean, this is unimpeachable in the sense that it's coming from attorneys 1, 2, and 3, employees 1 and 2, a PAC representative, you've got tape recordings, you've got texts, you've got photographs. All of that is not stuff that was created by the FBI. This isn't sort of like just what the FBI quote found in a search, which they get to say.
Not the third degree,
Right. These are
Klieg,
his people, and they're contemporaneously saying this. So the strength of the case, and any concern that this could be analogized to Pence or to President Biden's cases just goes away if you actually just read the charges. So, and then the final thing, which is the biggest sort of wild card, is Judge Cannon. And I'm just going to be fascinated to see what DOJ does there, to get definitive information about how she got selected, and then to understand what DOJ's strategy is going to be. Because it's, as I can see, it probably wasn't that unforeseen that there would be a sort of lively prospect that she could have gotten the case. So I'd be fascinated to know about that internal deliberations, but what they're going to do, whether they're going to try to move to recuse her, whether they're going to try to build a record for recusal when she does the same kind of inane things that she did. And inane is probably a polite word, what happened.
She was really singular.
Yeah.
Yeah, Norm, we were reminding of it, and she doubled down twice before, but we'd also pointed out that the big risk here is not that she somehow throw the case, but that she delay it past the election.
Right, exactly.
That will be hard to reverse.
Yeah, she could just give a pocket veto in terms of when it gets done. And there obviously are lots of ways to do that. I mean, they're just the SEPA litigation alone, but just also, look, she was a master at delaying things, the first time around for something that, Harry, you and I have never seen. I mean, the idea that there was going to be a criminal search and then you're going to have a judge saying, by the way, you can't even look through the material was.
Yeah, she was really head and shoulders above everyone in the last few years. Let me ask your trial lawyer's thoughts about Nauta. What happens here? Is he just gonna, do you see him possibly pleading? They've got his second statement.
Yeah. So, Donald Trump did what he does do, and he did during the Mueller investigation, which he immediately issued a press release talking about filled with adjectives about how he's wonderful and strong and basically good looking and, and young and virile and, it's like whatever adjectives you want, that's what you are.
His valet.
Right. Exactly. So it just went on and on, which basically was, please don't flip on me. I've heard that his counsel is being paid for through Trump means, so that obviously.
And it's a high end counsel, right? I forgot who it was. Is it Woodward?
Yeah,
who's
Woodward,
the counsel?
who represents various other Trump allies.
No, he's an old hand down there. Yeah.
So, I think Donald Trump has learned from his experience with Michael Cohen that if you cut them off in terms of legal fees, they can flip on you. He gave Trump gave the same sort of statements with respect to Manafort, with respect to Weisselberg. I mean, so that's sort of a standard operating procedure for him, which is to try and keep those people close. I think any independent defense counsel would have had and would continue to have a serious talk with the client about the fact that, absent jury nullification, that you're going to get convicted. I mean, there's the proof of a felony, and the proof to me appears to be overwhelming. In terms of witnesses and documents, it just seems like a rock crusher. And so, and he's got a way to avoid jail, which is to simply tell the truth. So, it really, I think in some ways he might be thinking about his future, which is maybe he'll avoid jail, maybe he'll get a pardon, and then he's in good graces with someone who's very powerful and very rich. So that, when he's thinking about what his life looks like down the road, he sort of decides, I'm putting all of my chips in the pardon basket.
And they can pretty well get the truth through Corcoran, I think, and whoever this second employee still unidentified is. So if he stays clammed up, I'm not sure what it avails him. But obviously, they gave him a chance, and he stood hard, and they said, we're going to indict you and make you a conspirator. And he, said, all right, I'm ready.
And by the way, one thing you and I know is you never, ever, ever threaten something like that and don't carry through.
That's right.
Your credibility is shot. Like if you're not ready to do it, don't threaten it. But if you're gonna say that's what's gonna happen, if they call you, you can't be calling you a bluff. You have to just
Smith doesn't seem like a bluffer in poker.
Exactly.
All right, Andrew, you've got to go. I just want to, any general thoughts we haven't plumbed in these 11 minutes, and very good of you to squeeze us in.
No, I'm really sorry that I wasn't timely, but I'm happy to join you, even belatedly.
Right.
No, I actually think the big open issue is the judge.
Yeah. And I just want to second what you said. Look, there's something very Trumpian about it, and they understandably focused on the obstruction. This is me, mine. But they were able to frame it, and he did this at the presser as well, as it's not simply his sort of megalomania, but it really put the individuals and the country as a whole at risk. That's, I'm sure you won't have Republicans falling into line with that, but it's just a very strong counter narrative to, a boxes case, which is what he's going to try to make it.
Yeah.
I will say on the judicial recusal, although it's not it's an uphill battle. I do these conflicts issues for a living. It's not a very good living. Under 28 USC 455, I think there is a powerful argument to be made because this was so far outside the norm. And there's a good 11th Circuit case, U.S. v. Martin, that establishes the criteria. There's an analogy to be drawn. The 11th Circuit has shown that if behavior is outrageous and repeated enough, and Harry and I were saying earlier, Andrew, every time we thought, wow, she's far out on a limb, she jumped further along. So,
well, you'd think that after the first reversal, I thought, okay, well, she'll be chastened. And nope, it was just bring it on.
Yeah.
So that does fit the pattern where in the past the 11th Circuit has acted. That's highly panel dependent. And I don't want to give people false hope that unlike Trump's liability here, that it's a slam dunk. Doing these for a living, far from it. But there's a powerful argument to be made, and I suspect we're going to see that argument emerge.
All right, gives us something to talk about in a couple weeks, and I hope we will. Until then, I wanted to finish as I started, saying no to gentlemen I'd rather be talking about on this big day. Norm and Andrew, you brought a note, so it's okay that from Ari Melber, it's okay you're late, and I hope we can do it again in a little bit down the line. This ain't going away.
Sounds great.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.